We have quorum now. Oh, thanks, Brandon, for starting the webinar, and we're being recorded now. All right, so meeting called
Hey,
to order.
sorry, can I jump in really quick?
Oh, Sean, yes?
I was able to join on my phone, but was not able to join um, from my desktop using the web browser. It still is the spinning wheel, and had invited somebody else to join, and they're also having a problem. I don't know if Courtney is on the line now, but she was emailing me saying that she couldn't get on. Okay,
Okay.
now it's working on the desktop. I don't
Okay.
know, some sort of issue with logging in.
Yeah, if there's a member of the public, they won't be able to use your link. Okay, so there's someone.
No, it's the public link. Yeah.
Oh, that was a
Okay.
public. Okay.
Okay, good. She's there.
All right.
Sorry. Had some technical issues there. Sorry.
No, thank you.
Well, I also had technical issues, and
Yeah.
thank you very much, Derek, for assisting.
Okay, so I know there's a couple members of the public watching, so when we get to I'll go through the agenda items, and at the end of discussion, I'll ask if there's any public testimony, and you can raise your hand, use the raise hand function, and we'll promote you to be able to speak to the panel. So just wait until the item that you want to talk about gets called up. So yeah, so the first item was A1, that was the roll taking and quorum determination. I noted who's here. Well, we have a record of who's here. And as usual, if there's anyone in the room with you who's over 18 or who's under 18 and has personal business before us, please make that disclosure now. Otherwise, seeing nothing, I'm going to move on. And I assume there's no member of the public who wants to testify about this item. So Brandon, if there are any hand raises, please let me know. Okay, so as I mentioned a little bit earlier, moving on to the non-action items, we're going to take things a little bit out of order to let some of the other pigs talk first. So I'll ask the Birth Heritage Pig if they have any updates for us. This is going to be item B1B. So does any member of the Birth Heritage Pig want to give an update?
I'll start, if that's okay, Jeff, because he was with me on our last meeting. I don't want to go into a lot about what we submitted because we did submit it in a timely way and hoping people were able to read it. You've heard about, I know my personal position on allowing identifying information for children of donors and surrogates, so I won't go much into that. And basically, Jeff and I had a discussion and we agreed that we would support the amendment that the Uniform Law Commission sent, Article 9, to be added to the uniform law that's proposed by this group. I guess the caveat would be we haven't seen the language of the whole bill. We just want to make sure there's some conformity there. But some of that, could be technical. But I guess the support is for the article to be added. I did want to take a couple minutes because something occurred this week that I wanted to share that I think is relevant to what I've been saying. I was fortunate, and bear with me, there actually is a connection to what we're doing here today. I was fortunate to attend a couple of the events at the Festival of the Pacific. And why am I talking about that? Well, the Festival of the Pacific I've known about many years because as a young bill drafter, I had to draft the bills asking for appropriations from Hawaii to send the delegation to these festivals. And so I learned about it through that. I watched the opening ceremonies and they were broadcast and found them quite informative and quite moving, actually. And then yesterday, Nainoa Thompson spoke. Now, why am I interested in Nainoa Thompson? Well, when I arrived in Hawaii, I will be honest, I did not know much about anything about Native Hawaiians, about Hawaiian history. And I began paddling. I raced outrigger canoes. I was lucky I got to do the Molokai race. I survived it. It's something I'll never forget. And someone in our crew knew about Hokulea and what they were doing. And I was quite fascinated because I thought, this is really interesting because it began and their mission is, as they stated in the beginning, is to support the theory of Asiatic origin of native oceanic people, Polynesians, and Hawaiians. They wanted to make the connection. Subsequent DNA analysis supports the theory of purposeful trips to the Pacific. They were wayfinders. And NAINOA and the Polynesian Voyaging Society wanted to support that and show that the Hawaiians were not accidents. The Hawaiians showed up here because they were wayfinders, they were navigators. So NAINOA made some interesting points yesterday, and I think even his position has evolved over time. I've listened to him quite a few times. But he said, you know, again, why were we doing this journey, the original journey? Who were the people who discovered and settled Hawaii? The voyaging has connected us. We have found out. Why are there similar origin stories in Aotearoa that we have here in Hawaii? He said something that was interesting, because then he started talking about the climate crisis and climate change. And if anybody knows about that, it's the Pacific Islanders. Now, the other nexus for me is I arrived here 40 years ago with a husband who was an oceanographer. He was hired to study sea level rise. I have known about sea level rise for 40 years. There is data about it. There are oral histories about it. This is a real thing, okay? And people have been talking about it. So NAINOA has now understood that part of the mission of the Polynesian Voyaging Society is to gather people together about this issue, because people are losing their homes or losing their islands. And he also said, we cannot protect what we don't understand. So for many of you that grew up with your families of origin, if you know, you know. But if you don't know, you don't know. And when a government tells you you cannot know, is it the government's position to do that? Should the government be telling you no? That's one of the questions that I've always said about this. The last thing NAINOA said that I thought was really interesting is that we need to keep our promises to the generations. He said, I'm doing this now for my children, and I'm doing it for the children that are coming after. That's why we're now doing it. So his origin story now is for him, but he's continuing this for the generations to make sure that the children that come after understand this. Now, the last point I want to make, in the opening ceremony, the Chief Executive Officer of the Ministry of Education and Culture, and I don't want to botch his name, so I'm not going to say it, for Samoa, this is what he said: your genealogy and your identity are not negotiable. We're here to ensure that our identity is never negotiable. So my question back to our task force is this bill going to reflect the values of the Pacific and the people that we're affiliated with? And I don't mean me personally. I mean, you know, Hawaii is Hawaii. Or are we going to adopt what other people on the mainland don't really understand? That we are connected. So I appreciate you taking the interest in listening to me. But this just reinforced to me just yesterday why I still hold my position that people need to know where they're from. So thank you for listening. Jeff, I don't know if you had anything you wanted to add.
You said it far better than me.
Thank you.
So yeah, thanks for sharing that. So this is still in line with the proposal that we adopt what the ULC has
Right.
recently
Article 9.
done, right?
Yeah. Which,
And that mandates disclosure, or at least disclosure to the child, right, of the identifying information.
right.
So not just
both identifying and
right.
non-identifying being health, medical, etc. Even ethnicity, nationality, whatever. Identity meaning the donor.
Okay. And then from your pig, were you able to get like a sense of whether everyone is?
No,
on
so
board with that, or-
unfortunately we tried to meet, we did meet a couple times, and then it seemed like proposals to meet people, it's hard to say. I didn't get a lot of response. So I know Jeff and I decided to meet on on June 4th, because we felt like we know there's deadlines and we owe to report back
Mhm.
to the task force. So we did meet, and I think I just said what our position was. So
Okay,
if others, want to chime in, they should.
okay.
Yeah, I was guilty of being very, very late with the response, as in the morning of, which is my fault. I just had the combination of the other pig that we were doing, plus work, plus my son graduated on June 1st, and
Congratulations.
thank you. I was crazy enough to volunteer to run the all-night party on June 1st into June 2nd. So my re-entry process was slow. And so I didn't even, I confess, read the report until much too late, which is 100% on me. My position on this has I think been, established in the past. My concern has always been just simply imposing an additional burden on same-sex and infertile couples that is not imposed on straight couples, because straight couples make children all the time with not knowing who the genetic father is, unfortunately. But it's a large part of my adoption practice is notices by publication for unknown birth fathers. So we'd be imposing a burden on, once again, on people who already face a lot of additional burdens. We'd be posing yet another burden on them that we do not impose on straight couples. And as I've said in the past, families fall apart, relationships fall apart, record buildings burn down, and things. People, straight fertile couples, are not guaranteed to have this information available. But I understand there's a difference between that and intentionally creating people who are not going to have this information. I understand why that makes a difference to people. I've also pointed out in the past that, we have a much better ability now for people to identify their origins through things like Ancestry.com and 23andMe, with genetic testing available on request. My own donor, I got 75 pages of information on my donor, which was more than, I suspect in many cases, more detail than a lot of people have on their spouse when they get married. There are traditionally more limited options among known donors. Now, I've been told by a member of the public who I think is going to speak that's changing, and that some banks are not even doing anonymous donors anymore. But traditionally, what you would see available was a much smaller range of options among the known donors than the anonymous donors. And there was a very significant price difference. I looked at the California Cryobank yesterday, and a single vial of an anonymous donor is $1,195, and a single vial of a known donor is $2,195. And I was requested to buy 8 vials when I had my sons. So that's an $8,000 price difference between the known donor and the unknown donor for what my doctor considered sufficient for a single attempt at having a child. Once again, I go back to, these are people who are already facing a lot of burdens that are not faced by fertile straight couples. So, none of that is necessarily determinative, and I will accept whatever the outcome is. But those are the concerns I have for the people who would be in the position of having to pay to use a known donor and find and select a known donor. I hate to burden a community that's already made to jump through a lot of additional hoops. But I think, sorry, 100% my fault that that's not spelled out any better in the report, because I did not, I just didn't manage to make the time to elaborate on it, or to get to it before we sent it out.
Yeah, understood. And then, to be clear, and I know I've asked this at other meetings, but I just want to make clear that if we adopt the ULC, the UPA article, that just applies here, right? And so if people happen to get pregnant via an anonymous donor somewhere where that's legal, but they come back to Hawaii, they can still use the ART, like the ART agreement provisions to establish parentage, right? It's not like you're not able to establish parentage legally if you get your procedure done elsewhere. It's just that if you are going to do your procedure in Hawaii, that it comes with the disclosure requirements in the new UPA, right?
Is it even the procedure? Sorry, Judge Hall, you probably know this better than me. Is it even the procedure, or is it just the sperm bank requirements? So if the sperm bank is not actually located in Hawaii, you may not be bound by this. I think that's what Laurel, when we looked at it, wasn't that what we concluded?
Well, that's what I heard you say, but since I'm not an attorney, I'm not going to find on it.
Yeah, I think when we looked at it, it was really regulating the sperm banks themselves. And so Even if you, for instance, in my case, we didn't have anybody in Hawaii at the time, I don't think, or at least not that I knew of. My son's donor was from California Cryobank. So if I were to use California Cryobank and they were to use an anonymous donor, I don't think that would interfere with the process here in Hawaii.
And I
Chantal, is that
agree.
correct?
Yeah, I agree that the new Article 9, it's for the donor banks.
Donor banks, right? Okay.
Although,
Um,
as an interesting aside, I'm told California Cryobank is moving towards nothing but known donors. So this may be the way the wind is blowing.
Sean, you have your hand up?
Yeah, I just wasn't quite sure I understood about the burdens. Are you saying that it's generally more expensive to get like known donor sperm than anonymous donor sperm, or is it like maybe it will be more expensive if there's just less out there, or what's the actual burden if I wanted to do it?
Yeah, up until now, it has been the case, or at least back when I had my sons, that there were far fewer options among known donors. Although I think we have a member of public who's going to speak on this, and that may be changing. When I looked at the pricing yesterday, it was $1,000 more expensive per vial. It was almost double the cost per vial for a known donor versus an anonymous donor. Now, I don't know whether that'll change if the banks go to nothing but known donors. I don't know if that means they're all just going to be more expensive, or if they're going to have lower prices because there is no longer a premium on known donors. And I think just in general, for me, the thought of trying to restrict how certain couples can proceed when once again, obviously anonymous children whose birth fathers are unknown are born every day. It just seemed to me like it was imposing, and we don't require that people having children without the assistance of assisted reproductive technology prove that they can show the genetic and parentage background of the child before the child can be conceived, right? I mean, it's just, and it often doesn't happen that way. So to me, I'm perhaps maybe oversensitive to anything that seems to impose an additional burden on communities that already have to jump through a lot more hoops to have children. We don't require I don't know what the word would be, non-anonymity. We don't require known sperm providers to straight couples. We would like it. It's definitely preferable, but we have no way of enforcing it against regular fertile straight couples having children through natural procreation methods. So I become a little bit sensitive to saying that if you're in an infertile couple or a same-sex couple, you may only have a child if you can prove the genetic and medical background of the source of the sperm.
I haven't spent a whole lot of time thinking about how this affects different groups much, but it seems like this would apply sort of equally to anybody, right? I mean, it wouldn't be like, if you have a straight couple versus a same-sex couple using
No, it's
donor
really
sperm,
fertile
right?
versus
It's not-
infertile.
Right. Okay. It's not necessarily like a gender-based disparity
no.
or an orientation-based disparity. Okay.
No,
Okay. Thank
it's
you.
just if, the questions about cost and things, if it makes it even harder for those couples to have children, that's what I worry about. And honestly, I have my kids, so it's not up to me to make the decision for everybody else. But that's what I hate to see that those particular communities burdened with anything additional over and above what other couples face.
Laurel, did you have?
Well, yeah, I guess maybe I misheard what Carol was saying, but I don't think it's necessarily that they have to prove they know the genetic heritage. I think it's really up to the clinics and the donor facilities to keep the information. So in the event that the child is asking for it, then it's given to the child. I don't think it's a proof of who the parent is in order to conceive. I don't think that's the way I read it, but like
No,
I
no,
said,
no,
I'm a non-lawyer reading it, so.
No. I'm sorry if I spoke. What I meant was proof, having it has to be secured in some way or another. Children are born for whom that information is not preserved in any way with any person
Right.
through natural procreation.
Right.
So that was just the distinction I was making. And
So
this
we're
is not me. Yeah.
But this bill isn't about really natural. I mean,
No. But
that's not
it
addressing.
lays out the requirements for people who are not going to be able to proceed naturally, and it's going to dictate what they have to do in order to procreate.
Right.
So.
So it sounds like, I mean, this is just my impression of your your pig's presentation so far. It seems like there's general agreement that you're okay with the UPA language, but you do want, like, I know Carol wants to note all of the considerations that you know, that people should know about also. Is that kind of accurate? Like, if you're going to write up your report, you would still want to include all those points that you made.
Yeah, I think so. I think, it's a little bit of a technicality that there's kind of a loophole. And hopefully in an ideal world, it becomes no more expensive and no less available to have a known donor. If anonymous donors go away, don't exist anymore, then I have no issue with this at all. It's just when there's, $8,000 per attempt at a child is not an insubstantial price difference, and we don't know how that's going to go up or down in the future. But for some people, that could make the difference between being able to have a child and not being able to have a child. Now, maybe, maybe they'll pass laws that say you can't charge a premium for known donors or something. I don't know, but that's just the concern.
Can I ask a clarifying question? This is Thaddeus. Thanks for bringing this up. I'm not as familiar with this, and I'm also not a lawyer, so I just want to acknowledge that. But Carol, a lot of my role, I think, in our PIG is just ensuring that equity piece for people who are non-heterosexual, non-cisgender couples as well. So I didn't realize that there was this possibility. But is the language that's being proposed requiring that people would choose the non-anonymous donor, or I'm just not I don't know what the language is well, or is it really, I heard folks saying that it was for the sperm banks, or
it's for the, it's right now it applies to the sperm banks, and therefore it does not apply to if somebody goes to a bank in a different state that's not subject to the same regulations. So for instance, at the risk of over personalizing it, my children came through California Cryobank, they would still to be able to be done with an anonymous donor, except for the fact that, and I think we do have a member of the public who's going to speak. My understanding is that California Cryobank may be going fully known donor, which I'm all in favor of that. I mean, there's no question in my mind, it is preferable to have children have access to that information. It's just a question of, will it prevent some people from even being able to have kids? And that's what I worry about.
I had something as a member of the PIG. As someone who you're suggesting it might affect, I support the going in the direction of the known donor when the child is an adult, but I don't feel like we can compare the pricing today versus a future time when there's only one option. I think it narrows down to fit the market as well. But the extent that it's a burden when the costs can be so huge. I didn't do it in America. I don't know the costs in America, but I think it's minor, the current cost difference compared to the burden and the potential of when you're trying to place the child first, and what they may go through in the end. I'm definitely very much in favor of the known donor approach.
The other clarification I wanted to add too, just for everybody's general information, which once again is not to argue against known donors, is I don't believe any of these things obligate the known donors to actually participate, interact, have any relationship with, or even share any further information with their offspring. So you can have the name of your donor and reach out to that person, and that person can still say, I'm not talking about, I have a question. Tyler, I see, keeps texting, and I have no issue with it because I believe he's going to speak in person, but if people are supposed to testify at a certain time, are they supposed to be sending messages, kind of testifying while we're talking, or are they supposed to?
I thought so. Yeah, just for people to know that the chat won't be part of the record of the meeting. So, and I'm not checking really the chat.
Yeah. Okay. I mean, we definitely, I think we should hear from him, but it's a little distracting. And so I'm wondering, I don't know if the public is technically supposed to be commenting the entire time we're discussing, but anyway, so that's just another thing to know, just in general information, is having the name of the donor does not mean that you're going to get any information out of the donor. It doesn't mean you shouldn't have the name of the donor. It's not a reason to oppose getting the name of the donor, but it has its limitations. They're not required to maintain contact or provide information. No worries, Tyler.
So Lauren
So-
can- okay, yeah, I'm sorry. I'm not reading the chat while we're talking, so I'm sorry if anything's getting lost
No,
there.
no worries. No
Gonna-
worries.
I will call on the public to testify, and they can share their thoughts.
It sounds like Courtney has information too.
Mihoko, did you have your hand up?
Yeah, I just, and as we deliberate over this, I sort of wish that Dr. Frederelli was on today, because I just also wanted to see, I think, I'm just wondering if adopting something like this, and maybe folks that are members of the public could comment on this as well, is whether or not there would be a chilling effect on the donors themselves, right? Who give under a variety of circumstances, but if anyone has perspective on whether or not that would actually cause donors to not want to donate, and then it would lessen the pool of what we have available for couples or people who want to use assisted reproductive technology in that way. It's just a concern, and be interested in hearing others' perspectives on that.
Yeah.
I'm not an other, but I can tell you that my sense has been that our donor is very averse to being known. So he would not have, I don't believe, been an option if anonymous donation was not an option. Of course, I'm super biased because I think my kids are great the way they are. But I believe that it will have an impact on the pool. But maybe once again, maybe culturally that'll change, and over time we'll have just as big a pool of known donors. I don't know, and I'd be interested in hearing from experts as well. But I definitely do not believe everybody who has agreed to be an anonymous donor to date would have agreed to be a known donor. And ours,
Right.
and I won't go into the stories, but our sense is that he is extremely averse. He doesn't even post like photographs on the internet or anything. It seems like he really wants to remain anonymous.
Does anyone else on the task force have a comment or question? Oh, Jerry, go ahead.
Yes, we are having a really good discussion on this issue. I know that it also impacts the adoption statute, and I've always felt that not only the Uniform Parentage Act, but also our adoption laws should have been included in terms of our proposed recommendations, because there is this overlap. But with regard to this known donor versus unknown donor, my understanding, a lot of it is having to know the defects, if anything, their biological defects that they may have had, basically their health, whether or not there were health concerns involved that should be known to the person who is deciding to use that sperm. Carol, my question is, you have an unknown donor, but do you
Yes.
have the health background of that individual?
Yes, we have. Like I said, I received about 75 pages of information on my donor before I made my final decision with him. And so, yeah, I joke that I know way more about him than I did about the guy I dated for 5.5 years that I probably would have married and had kids with had things gone that way. So that's one of the reasons I don't have as many qualms about raising kind of the Russian judge perspective on this, because between the ability to figure out your genetic background and your ancestry through, the recreational DNA testing available these days and the very extensive medical information available, I suspect with the testing that is done that a lot of people using donor sperm know more about the genetic and the medical background of their donor than most of us do about our parents, because of the level of detail that is required and the level of testing they do. So it's certainly not a question of if they're anonymous, we have no information. And once again, and these are all just practical considerations. If you have the name of your donor and you reach out to your donor at age 18 and say, okay, Ben Smith, I would like to I would like to meet Ben Smith. Ben Smith can still say no. And you can say, I would like some medical information from Ben Smith, and Ben Smith can still say no. So having your donor's name, it has a lot of value. It does not guarantee any more detailed medical information than you're going to get up front from the sperm bank. But luckily, not having your donor's name also does not mean you don't have medical information, because they supply a lot of that in the process as you're making your selection.
Did they give a, sorry, Carol, did they give you updates though? I mean, have you gotten information? So
I have
the-
not received any, but I haven't gotten any. I don't know if there have been any. I will say I have a, which is a different issue about maybe limiting donors. I have a Facebook group with approximately 20 families, about 40 progeny that we know of. So we get medical updates from a lot of half siblings, but
okay.
I have not received anything from the bank. I don't know. I haven't reviewed in a long time their policies. I would assume if something really serious came up and it was reported, that they would let us know, but who knows if the donors report, right? There's a lot of unregulated aspects to donors in general, and a lot of it probably wouldn't change even if they agree to reveal their name. If they agree to reveal their name, that's not necessarily going to impose an obligation to provide medical updates. That's not necessarily going to impose an obligation on the number of children they can have. I think the question of regulation of sperm banks and ova banks and embryo banks in general is another whole significant issue that has not been addressed adequately yet.
Sean, I see your hand raised, button is up.
Yeah, sorry to go again. I just, Jerry mentioned something about the sort of scope of what this group is doing too, and I probably missed some conversations where that was defined, but yeah, I mean, I've seen the recommendations in the Legal Parentage PIG about recommending consideration of revisions to the adoption laws. I mean, I think it is within the scope of what the Act says. I mean, it's recommending amendments to existing parentage laws. Adoption is, touches on parentage. So I don't know. I'm not completely convinced we need to narrow our scope that much. I know it's a little bit much to go like overhaul the adoption statute now that we're this far into this, but I mean, I think if there are sort of common sense recommendations about the adoption statute to support what we're doing here, that makes sense.
Yeah.
And then I also just wanted to say that I would like to hear Courtney and anybody else's comments on this, specifically Courtney, because I know that she was, involved with the UPA's recent amendment, and so it might be helpful background information for this group writing a report, since we're talking about adopting what they came up with.
Yeah.
Thanks.
So yeah, I mean, I think you're right. We're not prevented from, if we had wanted to, making some proposed draft amendments to the adoption law, but it is kind of, it would just kind of be a lot for us to take on right now. So what the Legal Parentage PIG did is not, we haven't like recommended specific language, but we are, I think, contemplating urging the legislature, at least in our report, to consider that, to consider the fact that right now unmarried couples cannot adopt, and to consider that in connection with the changes to the parentage laws that we're going to propose. But yeah, you're right. If we really wanted to, we could come up with language, but that just is.
I think we need another year if we
Yeah.
were going to try to tackle another whole statute, because our adoption statute is, as Hall can tell you, is very outdated. We get asked for things all the time that we can't provide, like, get a judge to issue a declaration that the payments made to the birth mother were reasonable and stuff. And I can't, because our law doesn't dictate what constitutes reasonable payments to the birth mother. So we're definitely way behind. And I think the one place there might be a little more overlap I was wondering about today is if we at some point consider a putative father registry for unknown, fathers, which is in some adoption statutes, and how that would interact with this. But I think it'd be very hard to try to take on the adoption statute on the timeline that we have now. But I welcome Judge Hall's comment on that.
Oh, no, I'm not looking to add to any of our work, even though I completely agree that the adoption statute could use some updating to include allowing for non-couples and non-single people to adopt.
So yeah, I know we have people waiting in the waiting room to give testimony. Does anyone else from the task force have comments or questions before I ask for public testimony? No. Okay, so I know that Tyler was in the waiting room and wanted to talk about this agenda item. Brandon, could you let him into the meeting? Okay, I see Tyler's profile picture. Tyler, could I ask you to keep comments pretty brief? And I see another person wants to talk. We can let them in after this one. Yeah, Tyler, if I could ask you to keep comments kind of brief, and then panel member or task force members, if you have any questions, we can, please ask him at the end of his comments.
Thank you. Aloha, everybody. I have 4 slides. If I could share my screen, I think it'll probably take 5-10 minutes at most.
Yeah, we can share screen. We also already circulated these slides. So if instead of like reading them, if you can kind of summarize things, that would be great. I know some
Absolutely.
have to leave pretty soon.
Okay, I'll be quick. I've done it before. How
And
do I
if you
share my screen?
could introduce yourself and the organization you're with, that'd be great too.
Sure. How do I share my screen?
The green button.
Okay.
Is it an option if you're not a host?
It's enabled for any panelists.
Oh, okay.
Just a second, I'm sorry.
So you would click on the green button and then select which
If,
screen you want to share.
Would it be possible for somebody to bring them up for me? It's not letting me do that.
Oh,
I can just refer to them too if you want. I'll just launch into it. Let me pull the slides up. All right, my name's Tyler Levy-Stiff. I'm just here to be a resource. I'm a donor-conceived person. I'm an attorney. I helped co-found an organization called the Donor Conceived Council. It's one of 2 organizations in the United States that advocate for the interest of donor-conceived people. I'm going to talk briefly about why I think mandatory identity release makes sense. But I do want to note a few things at the outset. One is Article 9 was updated to require identity release. It only regulates It only regulates commercial entities, sperm banks and egg banks. It was something we worked a lot on at the Uniform Law Commission. There was a very intense stakeholder process, and the way Article 9 works is it doesn't touch the adoption laws. It just basically tells sperm banks you have to, when people come in that want to be donors, you have to ask them to provide informed consent to the release of their identity at 18 if somebody requests it. And they have to maintain that information as a regulated entity.
I'm sharing this. I think I'm sharing the slides that you've sent.
Thank you so much. Yes, if you could go to slide 2.
Can you see that?
Yes, I can. If you could go to slide number 2. There we go. What the research is, so I just want to clarify that we're not talking about touching the adoption statutes here. One point I want to make is that research has found that non-identifying information is not adequate to satisfy the information needs of donor-conceived people, similar to adoptees. Sorry, I'm jumping around because I lost the slides. This is research from the Sperm Bank of California. This is a sperm bank that has run
I think sharing the screen kind of crashed our computer, so I'm not going to try that again.
Okay, I'm sorry. I'll be quick, I promise. Non-identifying information was not adequate to satisfy information needs. This was research done, peer-reviewed. Found that most people that requested the donor's information wanted to learn more about the donor as a person, not just medical information. Most requesting people were also interested in contacting the donor. They weren't looking to replace a family member or even have a relationship, but they were interested in some contact. So that's just to show that non-identifying information is not adequate in and of itself. Also, identifying information can be critical to obtaining updated medical information over time, as Laurel mentioned. Why does it need to be mandatory? This is a really important point, I think, because we don't know in advance which donor-conceived people are going to want the information. Some people don't care. Some people care a lot. It runs the gamut. I'm the oldest of 6. There's twins, triplets, and me and my family. Some of us care a lot. Some of us don't care at all. The second point, which has been referenced, and I'll just briefly touch on this, is that DNA testing has made anonymity illusory. Donors therefore need to understand and accept this before donating. This is part of the informed consent process. And we feel strongly that donor-conceived people should not have to resort to a DNA test to identify the donor. It leads to bad outcomes. It can be very messy, and Article 9 provides an orderly process for disclosure of the information. The supply issue, countries that have moved in this direction have not seen a decrease in donor sperm supply. This is a figure, there's a figure in the presentation from the United Kingdom showing that what's really at issue is the demand has gone up a lot, and the supply continues to go up, but the demand is even faster than the supply. Almost all the major sperm.
I'm just gonna make a little announcement. So I know some people had to leave at 2 o'clock. I think we have enough, and I know Thad just left. We have enough where as long as we have 9 people, we'll still be okay. So I think we have 11 right now after Thad left, so we can afford to lose a couple more. But anyway, just wanted to say that in case there are people who have to leave. But yeah, I'm sorry, Tyler, for interrupting.
It's okay. I have 2 more slides. All the major sperm banks, with the exception of maybe one in the United States, require that all new donors be identity release donors. I want to point out identity release donors are not the same as known donors. Known donors are very different. Known donors are where it's usually a family friend or a relative that provides that's known from literally from the outset, as opposed to ID released donors where the ID is not released until 18. Research has found that most egg donors also prefer identity release. This is peer-reviewed research. I'll skip over the legal slide, and I'll just mention briefly with respect to other countries. Several other democracies require identity release. Australia, New Zealand, United Kingdom, several countries in the United European Union. I think I would encourage this committee to look at the New Zealand law, because there's some really interesting parallels there with the native, indigenous, First Nation population there, as it relates to releasing identifying information to those donor-conceived people, that people that were conceived through donors who are part of those populations. The last point I want to make is that the ASRM, which is the leading medical body, reference was made to doctors. The leading medical body in the country has endorsed identity disclosure. This is a quote from a 2019 opinion where they say that the planned orderly disclosure, if all agree ahead of time, has the potential to satisfy the developmental needs of the child who enters young adulthood. I want to stop there. I really appreciate. I'm just here to be a resource, not to be a bull in a china shop and tell you all what to do. But I do want to let my colleague Jamie speak for just a couple minutes, because she grew up with very different circumstances, and I think it's of relevance to the committee. So thank you.
Can I take something real quick onto a point Tyler just made, because it didn't occur to me before now, but it's actually in support of what he's saying. It is an interesting thought that having the identity of a donor in Hawaii could make an additional difference, because things like Kamehameha schools, you have to be able to prove ancestry, not genetics. So in terms of being able to prove a familial line for purposes of things like KSBE, then that could be another advantage, which is probably unique to Hawaii. That's it. Thank you.
Okay, thank you, Tyler. Does anyone have, I will move on to the next person. Does anyone have questions for Tyler before we move on? No? Okay, Brandon, is there, I think it was Jamie who wanted to testify on this also? Can we let her in, please?
Hi, are you guys able to hear me?
Yeah, we can hear you.
Great. Hi, my name is Jamie, and I am an advisor to U.S. Donor Conceived Council on LGBT families. This is an issue that's very personal to me, as I am a donor conceived person who faced family separation from my siblings and my non-biological mother as a result of the lack of parentage protections for LGBT families. And so this is an issue that I've been working on across the US. Identity release provisions in Article 9 apply to all families equally, regardless of sexual orientation. This is not an extra provision on LGBT families. It's all families forming their family through third-party reproduction, particularly donor conception. I believe that the real burden is not placed on families through identity release, given that most major banks and agencies in the US are moving that way. I believe that it's on the need for second parent adoption and additional provisions to secure the parent-child relationship in LGBT families that are not placed on heterosexual couples. I believe that that's the real burden and the real concern for families because of the risk of family separation that remains in many, many states. I think, so I've connected with my donor as an adult, and research also backs up his experience where he tried to provide medical updates to the bank and they were not accepted. And so I was able to learn more information through connecting with him. And the way we connected, he actually had found us and made accidental contact while stalking, looking at our social media. And that's supported by some research on donors that 97% of anonymous donors and 100% of identity release donors indicate that they had thought about the offspring who may have resulted from their donation. So this is not one-way interest. This is very common for both sides of the dynamic to be interested about one another and seek more information. So I don't want to go on for too long, but I'm happy to answer any questions about this issue and the intersection with LGBT families that anyone might have.
Yeah, thank you. Thank you for sharing. Does anyone have questions for Jamie? No. Okay, I see Jeff has to go too, so I think we'll be okay. 1, 2, 3, 4, 5. Oh, 6, 7.
Thank you,
8,
Jeff.
9, 10. Okay. Yeah, Lauren, as long as you can stay on, that would be great. Okay, so if no one has questions for Jamie,
I'm sorry, you need me to stay on to keep quorum.
yeah.
Okay.
Thank
Please.
you.
Thank
Will
you.
do.
I
Okay.
just wanted to note that I have to leave at 2:30. So if we need to vote on anything, if we can try to do it before 2:30, that would be great.
Great.
Yeah, just a reminder, I'm the same.
Yeah. Okay. Thank you, guys.
We
All
still
right.
have Courtney, right? Is there a Courtney on there?
Sean.
Yeah, Brandon, is there another member of the?
She's still here. I mean, I would invite her to give some perspective from the reporter of the UPA, like how the conversations went. I mean, there was a recent change and there was a reason for that. Kind of like to hear it.
Okay. All right. Thank you, Jamie, for giving your perspective. Brandon, if you could, thank you. If you could let Courtney in to the meeting. Thank you.
That work? Can you hear me?
Yes, we can hear you.
Great, great. Well, thanks so much for all your work and for allowing me to speak to the committee. So I was a reporter of the original 2017 UPA and then also the reporter for the recent amendments to Article 9. Just quickly, actually, just to make sure everyone understands how Article 9 works. So as originally drafted, it required the banks to collect both non-identifying medical information and identifying information from all donors. It required the dissemination at any point of the medical information to the parents as well as to the child. And with regard to identifying information, it allowed the donors to choose whether they wanted that information to be disclosed upon request by the child at age 18. The recent amendment changes that requirement with regard to disclosure of identifying information. So it is now a requirement that all donors agree to the disclosure of their information upon request by the child at or after reaching age 18. And I think the committee made that decision for a number of reasons, some of which have been discussed. The fact that if people want to try to track down the donor, there are ways of attempting to do so. This provides an orderly way for that information to be disclosed. It ensures that the information won't be disclosed until the child is no longer a minor. If it's disclosed when the child is a minor, that does raise parentage concerns and concerns about the safety and security of the intended family. It was not unanimous, though. I mean, there were people on the committee that did not support making this change. And I think the reasons for not supporting this change are ones that are similar to ones that Carol mentioned in her comments. So I think there were concerns about the impact on supply and cost. As Carol mentioned, it is true that currently there are sperm banks that charge much more for identity release sperm. There is some concern that there will be donors who will choose not to donate if they cannot continue to at least start off as an anonymous donor. And we just don't know. We don't know what the impact is. It is true that there's been some studies of the supply in the UK, which now requires disclosure of identifying information. But indeed, actually, we don't really know what the impact on the supply in the UK is because 75% of the sperm in the UK is imported from other countries. So it's just hard to gauge exactly what the impact of banning all anonymous donation is on supply, given how fluid and porous the market is. And I will say, I think there's particularly concern about the impact on the supply of donors of color. There's already a shortage of donors of color. And again, we just don't know what the impact of making this change would be. One other point I wanted to flag. So there's been some discussion about whether this change is impacting same-sex couples differently. To be clear, it's true that these rules apply equally to all families who are accessing donor gametes. But to be clear, the reality is that the vast, vast majority of people today who are trying to access third-party gametes are either LGBTQ people or single parents. They make up about 75% of the market. So there's just a small and declining number of different sex couples who are using third-party gametes because technology allows them to use their own gametes even when there's low sperm count of a male partner. So in practice, it is having a different effect on same-sex couples and single women because, again, they are much more likely to need to use donated gametes. I think those were the, and sorry, one final point, just to maybe flesh out some of the statistics that Tyler pointed out in terms of who wants this information. The available research suggests that only a minority of children who have access to identifying information about their donors seek that information. Most of them do not want this information, which again, some do. And the question for you is what to do for those children who do want access to it, but actually most do not. Most do not want this information. Right, 40%, as Tyler said, an estimated 40% who have the right to access this information seek the information. Mm-hmm.
Carol, I see your hand is up.
Yeah. I just had a question. I was thinking back to what Jamie said about the fact that it's not a one-way benefit. And to be clear, I'm not advocating this. I assume there's no proposal on the table at this point that donors should be entitled to receive information about all their offspring, right? Even though that was pointed out as a benefit, because I could see a lot of issues with that.
That is not covered by Article 9 of the UPA.
Yeah. And so nobody's, to your knowledge, nobody's actually pushing that idea as well.
It has not been pushed to the ULC.
Okay, thanks.
Okay, thank you, Courtney. Yeah, does anyone else have questions for Courtney about the ULC process? Mihoko?
Courtney, thank you for your comments and insight. I was wondering where is Article 9 in terms of adoption across the states? Do you have an idea?
Yeah, so no state has adopted the revised version of Article 9, which was just approved in early 2024. I should know this. I think we have 5 states. Tyler, can you remind me? 5 states, I think, that have adopted, or 4 or 5, the original version of Article 9. I can try to find
Colorado, I think what Tyler is saying. I believe Colorado, Mihoko adopted something similar, but I think it was before the PA amended or revised there.
That is true. So Colorado is the only state in the United States that requires all donors to be identity release donors.
Understood.
Okay, thank you.
Anyone else have questions?
Just sorry, I'm raising my hand physically this time, but are Carol and the rest of this group, are you guys, is the recommendation what's on the paper, or are you guys going to circle back and come up with a recommendation, or are we all just going to vote on it? What's the process going forward on this issue?
Yeah. So we can talk about that. If no one else has questions for Courtney, I'll let her go and we can talk about our next steps. But anyone else? Question? Jerry?
Courtney, with regard to the review of Article 9 and this most recent change to the UPA on Article 9, what states were involved? What representatives and what states?
That's a good question. I do not currently have the list of the members, but I'm happy if someone gives me an email address, I'm happy to send the roster to someone so you can look at it.
Yeah, you can send that. I don't know if you
can tell you.
if you've seen our notice and agenda, but you can send it to Tammy and Derek. They're listed as the folks you can send like public testimony to.
Okay.
Lauren, it's actually on the if we sent them the whole amended, the list is on the third page of who was on it. Yeah.
And I think those are the official members.
Yeah.
If you want to also see a list of the stakeholders who participated, I think I can get that fuller list to you as well.
Yeah, that would be nice to
Thank
have.
you very much.
Thank you. Any other questions? No? All right, thank you so much, Courtney. Thanks for all of the public testifiers.
Yes, thank you.
Brandon, is there anyone else in the waiting room?
Tyler's hand is raised again.
Okay, Tyler, did you want to? Well, let's let him back in for a little bit. Hi, Tyler. Were there other comments you wanted to share before we move on?
Yeah, three brief comments just in response to Courtney. Major sperm banks actually testified at the ULC in support of this change. I think it's very significant to understand. Regarding the shortage of donors of color, which is a problem, the FDA did announce they're going to lift the ban on gay men donating sperm, which is expected to increase to some extent donors of color, because my understanding from speaking to the Sperm Bank of California is that many prospective donors that they get are potential donors of color, but had to be turned away because of that ban. And then the last point I want to make is 40% is a very substantial number of people that seek the information. It's not a minority. It is a less than 50%, but it's not like 5%.
Right.
Thank you.
Thank you very much. All right, so thank you, Tyler, and Brandon, you can let him back into the waiting room. So yeah, to Sean's question about what we do now. This goes for all of the pigs. So we can't do any votes now. That's not on the agenda. But what I wanted to talk about eventually is what we do at our next meeting. So the next meeting, I think, is our chance to have votes on the proposals of the pigs before they do their final reports. But if we don't think we need to have a vote on anything, like if it seems generally like we're all kind of in agreement about a pig's proposal, or if there's no comments or questions on it, then maybe the pig has enough where they can just go ahead and write their final report without any vote. And then we'll all vote on the final reports, but you know, we might not need like an intermediary vote before they can continue to work on their reports. So for this pig, I mean, what I'm hearing is that there's a lot of support for the adoption of Article 9, and there are concerns. You know, it sounds like there's the potential of, you know, like Carol was mentioning, having some disparate impacts, or you know, maybe having a smaller pool of donors. But I'm not really hearing strong objections to the adoption. So it might be that we don't need to take a vote on this, and it might be that the PIG can just proceed with their recommendation and, you know, finalize their report without a vote. Does anyone disagree with that, or does anyone think we need to have a vote on this before the PIG can go on to their final report?
I don't know about the timing, but you know, I haven't decided yet where I'm going to come out on it. And so I don't know that I would necessarily endorse the report as currently written. I've got to think it through some more.
Jerry?
Yeah, I would say that I also feel like there's impacts to this that we just need to think through, and same for me. I mean, ultimately, I'm not really sure where I come out on this issue. I feel like I have some concerns.
Okay.
And just want to, I mean, I think same with Carol. I just want to think about it some more, because this is I think it could have a major impact. I mean, my concern is mainly coming from the impact on, you know, supply.
Mm-hmm. Jerry, did you have a?
I think more time is needed to review what has been presented, and also to ask the group if we need more questions to do further research.
Okay. Yeah, so the hard part about doing further research at this point is that we have one more meeting, and then the meeting after that is when we're supposed to vote on the final report. So the final reports have to be in after the next meeting. So yeah, if we need to have a vote on what the contents of the report, or what we want the PIG to do as part of their final report, I think it has to be at the next meeting. So yeah, so we should, you know, take what's been presented here, think about it, and come to the next meeting. If this is what we want to do, come to the next meeting and say, yes, we want you to adopt Article 9, you know, put that into your final report, make, you know, note the concerns that we've talked about. Or we take a vote and say, no, we don't want Article 9, you know, and draft your final report with that understanding. Okay, I see Judge Hall has to go. Thanks. 1, 2, 3, 4, 5, 6. Okay, so we're still okay. All right, Sean, do you want to?
Just wanted to say that I would like to see where Carol comes out on this. I mean, I'm after hearing everything, I'm kind of, you know, leaning in favor of adopting as it was amended by the ULC. That's probably no surprise to folks on this call. We're sort of advocating sticking with the UPA as much as we can, and that's where it is now. And it sounds like there was compelling reasons, but I want to vote on this after having that PIG having actually met and discussed and come up with their best attempt at resolving their conflict if they can.
Okay. Carol?
Sorry, I'm sorry, I'm not as familiar with this process. So just a procedural question. So it's not that the PIG puts out its like a final report with a diversity of views, and then the entire task force votes on how it wants to proceed in light of that report. The entire task force actually influences what goes into the report.
Well, I think that's really up to the PIG. Like if you think you need the task force to resolve an issue before you proceed to your final report, then we should have a vote on it. But if you think that you can draft your final report without,
so there needs to be a decision in the final report. This is a split of opinion, if there is one. And once again, there's a lot to think about with what we've heard today and stuff. But it's not, the final report from the PIGs are not supposed to say this is our diversity of views or this is the two things we're considering. Task force, please make a decision. We're supposed to have a final decision.
I think we want you to have a recommendation, and you can note like the minority view too. And we would put the minority view into our final report so that the legislature is aware of it. But I think we need to have a recommendation in the report. I mean,
well,
do you have any?
my understanding is
Yeah.
that we need something so that we can proceed with the drafting. So we can't just say, well, you can or you can't, right? I think that there has to be at least one way forward, and then we can include minority opinions for the legislature to consider. But I think the task force itself needs to be able to present the draft act.
Right. That's why I thought the report is to present the views and then the task force takes a vote from there. I thought that happened after the report, but we have that vote before the report.
Well,
Sorry, I'm just trying to understand.
Yeah, we'd be voting to adopt the report and to incorporate it into the final, our task force's final report. So I guess if we disagreed with your recommendation, with whatever's in the report, we could like say we don't want this and we want to adopt the minority position instead.
Oh, okay.
But I'm trying to avoid that if possible. I'm
Understood.
trying to have a report that we already have looked at and everyone, is on board.
Okay, so these reports are kind of like, sorry for people who know this. So these reports are really kind of the justification for why the final recommended bill is the way it is. And so they have to be consistent. It's not an opportunity for people to discuss, evaluate, decide, and then make a final bill.
I think that's right. I think these are the components we want to put into the final bill.
Okay.
Again, noting any disagreements and noting minority views and everything like that. But we want to be able to make a recommendation.
We want the bill consistent with the PIG reports, whatever those PIG reports may be.
Yeah.
Okay.
Yeah, and part of it's like, trying to avoid coming to the, I don't want to have you guys work really hard on final reports that make a recommendation or have something, and then the PIG is just like, no, we don't want this at all. I mean, sorry, and the task force saying, no, we don't want this, and then that kind of leaves us with nothing to work with. So
okay,
I would like the PIG's final reports to already like include input from what we've been talking about. So yeah, I guess, yeah, going back to the upcoming meetings or the upcoming meeting then, I think that would be the time where if the PIG needed to have the task force tell it, this is what we think your final report should include, that would be the time to have a vote on it. Otherwise, if it sounds like, and from this discussion, it sounds like the task force itself isn't really, hasn't really come to a decision about what recommendation it ultimately wants to see. Maybe we do need to have a vote next time. The thing about the thing about voting, when we have a PIG though, is that between now and then, like we can continue to have deliberation at the next meeting, but we can't like have like an updated report from you guys before then, because a report and a vote has to be two separate meetings. So yeah, at the next meeting we can continue to talk about what we've already been doing, but we can't, you know, to the extent that you guys meet again and have like supplementary things to add, I don't think we can consider that at the next meeting, if that makes sense.
Yeah, my perception at this point, just based on the feedback I've heard today, is I don't know if we're gonna get to a place of agreement. I mean, maybe I'm misreading the group, but I think unfortunately it might have to be a task force, a whole task force decision.
Okay.
But I mean, we can try to meet, try to get people together. It's been challenging, so because I don't know, and again, this is where I understand the sunshine law, it can get interesting. You know, I don't even know what a majority of the, I mean, is if two people vote and that's it, is that the PIG report, you know, and I mean, I don't know if
No,
it's gonna matter.
Yeah, no, you don't need to have like
There's no majority.
majority thing.
I mean,
for
one
the
person
PIG.
could say, well, I'm the PIG and I met, but
Yeah.
that probably isn't real representative. So,
Hey, Lauren, this is Miyoko. Sorry, I if I'm a quorum breaker, I do have to leave. It's 2:30.
Okay, 1, 2, 3, 4, 5, 6, 7, 8. Yeah, yeah, as long as everyone else stays on for, I think we'll be okay.
Okay, thank you.
Yeah, so yeah, I mean, the individual members of the PIG can still, you know, if you want to do your own individual research and come back to the task force next time and tell us why you think, you know, we need to side with your position, then that's fine. I think it's just that once you have a PIG report, like what I guess, you know, we've received
gave
today.
one today, yeah.
Yeah,
Right.
then we can't have another one and a vote at the same time. But individually, you can all present your views. So yeah, it sounds like we might need to put that on the agenda for the next time. And again, this is for all the PIGs. Like if we need to have a vote on some policy or recommendation decision before you guys do your final report, then that has to be in the agenda. So I'd have to say like deliberation and decision making on X. So it sounds like we would put this on the agenda for next time as deliberation and decision making on like the recommendations of the Birth Heritage PIG regarding Article 9 of the ULC or the UPA, something like that.
I mean, it's probably better to put it on. I mean, the problem
Yeah.
is when you don't put it on.
Yeah.
I mean, you can always say we're
We're gonna-
deferring it,
right.
but it's probably better to put it on.
Yeah.
It's because of the way the law is.
And it sounds like that is the kind of the only or the biggest unresolved policy question you guys have, right?
It's kind of the meat of the whole thing, right?
Oh,
Yeah.
it is the whole, it's pretty,
So, okay.
And if it's on the agenda also, then Laurel knows we have to answer her emails this time. Sorry, Laurel.
well, yeah, I have a conflict for the next meeting, but I'll have to figure that out, I guess.
And then, yeah, once we decide that, then you can produce your final report and it can have whatever recommendation we vote on, and then also note, you know, the minority view, whatever that was. That makes sense?
Yeah, so I just wanted to ask whether, is it really just, yes, we include Article 9 as adopted, either the newest 2024 version or not at all, or is there some interest in considering the previous version? I think just to clarify for the whole
There is
task
no
force
previous
to,
version of Article 9.
is there not? I thought that there was some discussion about like a
I
different.
think there is an article. Yeah, there's
There
a
was
previous
yeah.
in
version.
2017.
I think so.
Yeah.
Oh. Yeah, I can tell you from my perspective, it's the current version, not going back in time.
So it would be the current version
Yeah.
or nothing at all?
For me, it would be.
That's just I'm curious about whether, is that kind of what we're looking at right now, or is there?
Yeah, I think.
Because I am aware that there's a different one, and as she mentioned,
Yeah.
it does allow for donor
Yeah.
anonymity. So are we considering no Article 9, new Article 9, or are we considering no Article 9, old version, new version? Like, I think we need to kind of frame it so that we know what, the whole task force knows what kind of discussion we're supposed to have next
That's a good
meeting.
point.
Yeah.
That can be on the agenda.
Yeah, well, no, what you guys can do as the pig is decide what you want me to put on the agenda.
Right.
Yeah. And what options you want the task force to consider.
So I think that would be most helpful, is the pig helping us kind of frame what should we really be looking at, and what is the decision that the task force should be making here. So kind of just guide our discussion for next time and vote. That's what I would request anyway.
Okay.
Yeah. Does that make sense to the Birth Heritage folks?
Yes.
Yeah,
Yeah.
it makes sense, I guess. Okay, we can take one more round on it.
Okay.
Lauren,
Yes.
before we lose quorum,
Mhm.
our next task force meeting, according to my schedule, is the 26th of July. Am I correct?
No.
No, we're gonna do
The 19th?
28th of June, right?
No.
July 5th.
Oh, whoops.
The
July
28th,
5th?
28th is the
Okay.
deadline for submissions.
Yeah.
Oh,
20
okay, okay.
and
Oh,
six.
yeah, I see. Okay, that's right. Number 9 is on the 5th.
Yeah.
Okay, thank you.
Okay. Well, yeah, so thanks. So yeah, so Birth Heritage Pig, I guess for you guys, let us know what you want to see, what the agenda item should be for
Okay.
next time.
Yeah, okay.
And if you have questions, let me know, or Sienna, know one of us will help you with crafting it. Okay, I know we're going kind of long. Maybe I'll just, before we lose, in case anyone else has to go, I'll skip to C2. It's kind of confusing, but so under sunshine law, like I was mentioning, we have these pigs. The pigs come back with a report, and generally you're only, pigs only do one report and then they're done. But we've been doing updates which are not, we haven't been considering those to be final reports. So I just wanted to clarify that, notwithstanding that we've had these multiple non-final reports, that the pigs have not been dissolved because of those that are, we're still ongoing in our original scope of work. So I'm just going to, clarify that on the record, that the pigs will be able to continue their work even though they've come up with these, interim reports back to the committee. So the only, I guess, to clarify that you can continue in what you're doing, I'm just going to have to dissolve the pigs that have already been created on September 29th, 2023, and the legal parentage pig, which we already dissolved and then reformed to add Sienna, and just reform the same pigs with the same scope of authority, the same investigative scope, and the same membership, and just clarifying, that you can all proceed as if you've never been dissolved. So, and I'm doing that via my powers as chair. We don't need to have a vote on that. And unless any members of the public wanted to testify about that administrative type of action, I'll move on. Brandon, are there any hands raised about that?
No hands raised.
Okay, thank you. All right, so I just wanted to get that out of the way before we lose quorum anymore. We also have the the formation of the drafting pig. I just wanted to do that like as soon as possible before I have to leave, but we could leave that for the next meeting if you think we can do that?
I think we can do that.
Okay. Otherwise, I think it might be more important to just go on to the other pigs reports. So I'll ask for the assisted reproduction and surrogacy pig. This would be item B1C. If they have any reports. Oh, Sean, you have your hand raised.
Oh, was this meeting supposed to go till 2:30 or 3? Or what was the?
Because of
There's no official end time.
Okay.
Have to leave at a certain time.
No, I do, and probably in about 15 minutes or so.
Okay.
And I don't know. I mean, I think that now that Judge Hall's gone, maybe some of the discussion around the legal parentage pig might be. I mean, better to defer to next time. I mean, it's just a thought. But anyway, please go ahead. I don't think the other group, the one that I'm involved in, the ART and surrogacy group, has any new. We didn't have a new report or anything. I know there was a meeting yesterday, but others can talk about that.
Okay. Well, I mean, similar to what we were talking about with respect to the birth heritage pig, if there's like a, like a policy, I guess disagreement within the pig that you guys need the task force to resolve before you can proceed, that should be brought up. And from the report that you guys had last time, it seemed like there was general agreement about everything except for that the mental health consultation.
Mental health testing, yeah, that's the one kind of
Mental health
outstanding issue.
consultation.
So did you guys? Yeah, I mean,
Carol, did you guys talk about this yesterday? I wasn't on.
We didn't really. What where that pig is basically we've now made it all the way through all of our sections. We've come up with a variety of proposed revisions for the purpose of either correction, clarification, or some minor policy recommendations, trying to stick as close to the UPA as possible. I think at this point, there's no, it's not like the birth heritage one in terms of there being a fairly significant kind of split of opinion on any topic. I think the mental health one has not been decided one way or the other definitively, or at least not formally. So I'd say that might be the only kind of open issue, but it's not highly disputed, I don't think.
I think I've seen the sort of preliminary drafts from Deirdre, and that was reviewed by others, but it sounds like we're leaning towards proposing to not include the mental health
I think that's,
at least in the draft. Yeah. But I mean, that's kind of where the pig is leaning. But I think it would be good to have a vote on that specifically, since there's.
Okay.
And I don't know if Courtney's still on. I wouldn't think she is after this long, but if she's still on, she's here.
She's there. Yeah.
Can I ask her? I mean, I don't know if we need to wait till Carol and I are done prattling on, or we can just ask her a question now.
I'm done prattling.
Okay. I'm wondering if she can talk a little bit about this issue, the mental health consultation requirement for surrogacy agreements, and how there's been deliberation on that, or whether that's advisable or not needed. I know we talked the last time about sort of how this group has been going back and forth thinking about reasons like that it may not be needed for intended parents. Yeah, if she's here and willing to talk, could I invite her too?
Sure. Brandon, could you let Courtney in if she's still, I think I saw her say that she's still here.
Hi, sorry. Yeah, so I can share, I mean, we modeled Article 8, the surrogacy provisions, on some statutory schemes that already existed, including Maine's, which I believe does have the mental health evaluation requirement for both surrogates and intended parents. There was some desire on the part of the drafting committee to have as many provisions parallel as possible in terms of requirements on surrogates and requirements on intended parents. So that was part of the reason for including the mental health consultation requirement for intended parents, to ensure that parallelism. I think there was a sense maybe of some members of the committee that some surrogates might want that information, just like some intended parents might want that information. It might, for some people, feel important with respect to their sense of the success of the agreement and how the relationship between the parties might go. At the same time, I will say there were concerns raised by other people on the other side, worrying about how this could facilitate discrimination against people with disabilities, including mental health disabilities. So arguments on both sides. And then finally, I guess I'll just say, if you were to take it out, it certainly would not affect whether or not Hawaii would be considered an enactment state. And of course, all of Article 8 is bracketed, so you don't have to enact it at all. And so, you know, particularly there, making changes to provisions, I think will not impact, again, whether Hawaii is considered an enactment state or not. And then I guess one final thing was just, there is some discussion about this. I know New Hampshire is considering making some changes to its surrogacy provisions, and this particular issue has come up there.
Courtney, was there any discussion that you know of just regarding, I don't know if other states share the challenge, the difficulty of just finding mental health care providers available to perform these assessments?
You know, I don't recall that ever coming up, but that seems like an important thing to think about.
Sorry, one last question. Was there any possibility this was a defense against the old, kind of more old-fashioned idea now of requiring actual home studies, which I know a while back was a thing?
So that was included actually in the 2002 version of the UPA. There was a home study requirement unless waived. And so I guess it's possible that that is part of what motivated some of the models that we drew from to include this. But again, I think, as I recall, the primary reason for including this was just the desire to have that parallelism for both for intended parents and surrogates on the other hand.
So I understand that. I think that means that there are folks that believe strongly that mental health consultation would be beneficial in like for surrogates, especially if it's a genetic surrogacy, but and maybe don't feel that necessarily that you would need that if you're an intended parent for like a gestational surrogate. Like I feel like there's different circumstances, but you're looking for some sort of drafting mechanism to make sure there's some, you know, is sort of neat and tidy and provisions seem parallel. Is that kind of it, or?
Well, I think the idea was that the act was imposing, you know, a lot
Kind of fairness, right?
on a surrogate, and that there was a sense that we wanted to impose some requirements on the intended parents as well.
Okay.
Yeah.
Okay.
Do you know, sorry, last question, Courtney, do you know if anybody's considered any alternatives? You know, one of the things we talked about because of the lack of availability and stuff was, you know, is there something clinics could do in-house, or
yeah,
any kind of half measures, which sounds bad, but is not intended to mean, you know, cutting corners.
So again, it is my understanding that New Hampshire is grappling with this issue right now, but I don't think that the language they ended up coming up with eliminated it. But I'm happy to ask around and see what people think. I guess one final thought, which is just, it is my understanding, but I can't say this from personal experience, that most agencies require this as a matter of practice.
Yeah. If you did have an example of language that was something short of a formal full mental health consult, but still did some sort of due diligence, I would definitely be interested in hearing that, or seeing that.
Okay.
Thank you.
I will ask, I'll add that to my to-do list.
Yeah, and just so all the pigs know, I mean, as part of your investigatory scope, right, you can ask people like Courtney or any of the other testifiers today, you know, questions one-on-one. You don't have to wait to do it in a meeting or anything like that. You can feel free to reach out to anyone you want, assuming they want to answer questions. But I'm just saying generally, yeah, you can, outside of the meeting, go and do your own investigations too.
And Lauren, I did that a little bit.
Right.
Transparently, I did contact Courtney, and I think it's super helpful for everybody to hear what she's saying. So thank you for joining today.
Yeah, thanks again.
Thanks very much. Thank you,
Tyler as well. I think Tyler's on the chat wanting to talk about ART as well.
He might have some testimony to share on this too. Unless anyone else has questions for Courtney, I'll let Tyler in. No. Okay, thank you, Courtney. Brandon, can you let Tyler back in, please?
I just wanted to know, we don't have my organization doesn't get involved in surrogacy. I just wanted to note though that ASRM does recommend that requirement that y'all are talking about right now. So that is the requirement is consistent with ASRM recommendations. And the second thing I want to mention is I have the utmost respect for Courtney as a scholar and a person. I just want to share concerns with how the deliberations of some of these ULC meetings are being portrayed. We're in a sense relitigating issues that were already being litigated before the Uniform Law Commission. I certainly understand sharing the context of the deliberations and answering questions about how it went, but based on what I heard, I'm just concerned that the committee's not hearing from, if we're going to relitigate it, we need to hear from everybody all over again, and we're not hearing from everybody. We're just hearing from me, and we're hearing from Courtney. Thank you.
Thank you. All right, any questions for Tyler? Brandon, is anyone else's hands raised in the waiting room? Does anyone else want to?
No other hands.
Okay, thank you. All right, thank you, Tyler. Brandon, you can let Tyler back in the waiting room. Thanks. Okay, so yeah, it sounds like this is still like you haven't come up with a recommendation. Like I think Sean, you said Deirdre might be drafting something that leans towards was it not
yeah, so not including that requirement. We probably need to talk again within our group before that's finalized. But I mean, I think major concerns have already been discussed around like availability of Hawaii-based mental health support that could satisfy that requirement, and that being too much of a burden initially. I think we're also aware of the ASRM recommendations, and the fact that surrogacy agreements are already in place without this requirement, and so it's a little bit like, do we need that or not? Are the doctors sort of already following guidance and recommending what what they should according to their own guidance, and to where we don't need that mandate, or is the mandate needed? I think with the people in our PIG, it's sort of trended that way of not including it, but I think we need to talk about it a little bit more. That's my sense of it. Of course, without having Miho or the entire PIG on the phone, I can talk as much as I want, right? So
we updated our draft with the most recent changes. I circulated it yesterday, and we're planning to meet in the next couple of weeks to come up with what we think will be essentially our final draft and provide a basis for the kind of final report.
Okay, great. Yeah, so if it's not like if you guys are all in agreement, it might not be something that we need to have a vote on at the next meeting. But again, if you find that like you just really can't proceed with your final report unless you get the task force as a whole to weigh in and tell you what to do, then let me know. So we can.
I don't anticipate that with this PIG.
Right. Okay. Okay. Thank you, guys. So we had the public testimony on that item. Unless your PIG has any other questions, it sounds like, like I said, if you guys want to vote, let me know. Otherwise, it sounds like you're progressing towards your final report. So, okay. So I'll try to have a really brief update from our legal parentage PIG. This is B1A. I think our written update kind of just speaks for itself. So I won't go super into detail about that. Basically, we just responded to the comments and questions and concerns that came up last time. Jerry had a bunch of proposed, amendments to the draft bill. We were all fine with those in our PIG. I know that Sean had raised a question about the denial of parentage provisions, and we actually agree now that we agree that there's utility in having the denial of parentage provision there. But when we spoke to Department of Health, they, raised all these concerns about it being too burdensome for them to have adequate staffing to do that. So we think we can still do it. It would just go through the uncontested parentage proceeding that we had proposed earlier. So basically, like, if you have an alleged genetic father or another presumed father, and he wanted to deny parentage, and you have this other guy who wants to step. I'm saying, you know, this should be gender neutral. I'm just like using some illustrative terms, but yeah, you have someone else who wants to step in to be the established parent. And then you have the birthing parent, you know, all three people could submit affidavits to the court, and the court without a hearing could establish parentage. We just don't, you know, and just based on the DOH's comments, we are recommending that not happen administratively, but just go to a judge who can review the paperwork and, you know, make sure everything looks above board. And then the other question was from Mihoko about whether allowing professed parents to go through this, you know, uncontested judicial procedure would somehow like discourage people using ART from executing ART agreements. And when we looked into it, we thought it probably would not do that, because it's still going to be easier for people using ART to go through the provisions, the specific ART provisions in the draft bill, rather than to, you know, submit affidavits to the court. That's kind of the quick and dirty summary of it. So yeah, I see Carolyn and Sean, you guys have questions. I'm not sure who raised their hand first, but
Carol did.
Okay, Carol.
I just had a really quick question. When I was looking at this last paragraph that was tagged on that said, task force is still concerned, if the task force is still concerned, definition of professed parents could simply be amended to add, a professed parent does not include the parent of a child conceived via assisted reproduction. It just made me a little concerned. You know, we think about what Deirdre taught us is the soap opera scenarios. If a female uses donor insemination to become pregnant with a child, she becomes, as a single person, or as with a former partner or something, and then later on meets somebody who before she delivers, who's going to be, or even after delivery, I guess, who's going to be like a parent to the child and wants to be a professed parent. Are we going to exclude that accidentally by doing that? If there's been any ART involved at all, they can't become a professed parent. I was just concerned if we're going to accidentally put up roadblocks in circumstances in which we don't intend to. So we don't even have to answer it right now, but it was just a concern I wanted to note, because I wasn't sure if
right. I think that would be the consequence of doing that. So it's really like.
But it has nothing to do with an agreement in that case, because she wasn't around at the time that the woman entered into the sperm donation agreement, so she couldn't participate.
Yeah, so it's really like a, you know, it's not that person, that the new partner would be barred from asserting parentage. I think they would just have to
go through the process.
Yeah, they could do VEP if they hold the child out as their own for 2 years, reside with them, become a presumed parent that way, then they could use VEP.
There's some timing stuff on the
Right.
ART agreements as well that may not actually prevent that person from becoming a parent through ART agreement. I actually don't, I'm not in favor of adding that language. I don't find it to be necessary to achieve what we want, but I think that if it was included, I don't think the effect would be as, you know, dire as you've suggested. I think that there are ways for the parent to become, or the incoming partner to become a parent, but just not through this channel. But like I said, I don't find it necessary to include the provision. I prefer not to prevent people from being able to use whatever method of establishing parentage that they can.
Yeah, that makes sense.
Yeah. Well, we're going to require agreements, aren't we? I mean, we're not making the agreements optional, so we hopefully can't discourage people from complying with law by using other laws.
Right, and it doesn't, you know, it doesn't make it easier to do it one way or the other, where it, like they slip through the cracks or something.
Yeah.
This system actually requires judicial review, so it's actually more stringent than the agreement.
Yeah, and that's why we didn't think that having this available, like, we didn't think we need this language, because we thought, you know, just because any professed parent can use the non-judicial, or can use the judicial uncontested provision. It doesn't mean like if people have an easier route, they're gonna abandon that route.
Well, and clinics, I've been working, I've done a lot of seminars for clinics in recent years. Clinics are not really supposed to be willing to do any of these ART procedures without an agreement in place anyway. And I think our clinics here are pretty educated on that. They know the risks to them are enormous.
Sean, do you have your comment or question?
Unmute. Yes. So denials and then professed parents. So I mean, thank you guys for doing all the research on the denials. I know I sort of set you off down that path by asking all kinds of questions last time.
That was a good question to ask, because we kind of had just, you know, and it was true that our assumption about DOH's reluctance and the burden on them was, it seemed to be accurate, but we did think, you know, taking a second look at it, we're like, we could make a path.
So I had a question about the DOH's reluctance, and
Mhm.
and not to sort of drive this too hard, but like, one, like the mention of needing like 2 high-level folks to handle this and not having them. So is that specifically for the denial process, or is that more broadly to adjust all of the changes that we're recommending to the VEP process? Because I'm trying to imagine how just this specific thing would actually be that burdensome, and then
Maybe
if
Mark,
there's more details around that.
yeah, maybe Mark or Jerry I think it was Jerry who had talked to the DOH records director. Jerry, do you want to elaborate a little bit more on what the
Lauren's good.
Excuse me, Lauren is here. He can probably, as he is the representative for the Department of Health, would be more appropriate.
Well,
We only have 8.
give me a few minutes. I have to go reread the email, but it did have to do with the complexity of the paperwork and establishing. I guess documenting is a better word, documenting the change. Give me a few minutes to see if I can quickly unpack it.
Wait, sorry, before
Yeah,
I go on, it looks like we lost, I think
quorum.
we lost quorum. No, we have 8
Did we?
people.
Oh,
Okay. There we go.
I'm saved by the bell. Okay. But it was a very process-oriented concern, and I do not work on. So I'd have to go back to my colleagues and get a more thorough understanding to better describe the burdens that they would face.
Yeah, I don't want to. Are we violating some sunshine law? I don't want to mess anything up. I did have more
I
questions
think we
though.
can,
We just can't
yeah, well, we
can't decide, yeah.
take action.
Okay. See, so Lauren and Lauren, that's convenient. I can just say Lauren and then I'm talking to both of you. Okay.
50% chance of getting it right.
So I guess like when I read this, I'm like, okay, yeah, DOH, it's a new process. It's going to be more stuff to do. Maybe need some more people, some more funding, even maybe. Okay, but the flip side of that is it's taking a judicial process and turning it into an administrative process, which seems more appropriate if it's not contested. So I'm imagining also that there would be some cost savings to the state, right? I mean, I could see how new processes might be so crazy that we don't, we want to take them cautiously. But on the flip side is if we're actually streamlining something, innovating in a way that's going to save the state, then maybe we should explore that. So I appreciate you guys like looking at this and recommending that we do this, but like, yeah, I didn't anticipate this sort of method of doing it, and maybe that's the best we can do. But if we are, I don't know. I'm imagining it's more burdensome to continue doing them in a courtroom than to having like an administrator in the Department of Health do it, right?
right.
Am I off base?
Yeah, no, I think it would. I think it would for the users. It would be easier to have it go through DOH. But we thought having something's better than nothing, right? If DOH is saying they can't, it's going to be too hard for them, or they're, I don't know.
Yeah.
Something they're opposed to, and that might hinder the adoption of the bill. The thought is
Well,
yeah,
better than nothing.
So here's something that I can comment on as the policy director. It would be unlikely that our concern about lack of resources to implement this would impede the policy passing. You know, those would be two separate things. We would grumble and stump our feet, and you know, I can't predict, but my recommendation to the governor would not be to recommend a veto because we did not get 2 FTE. There's a greater public good here to keep families whole that we recognize. And somewhere along the line, you know, we may have to ask for a delayed implementation date of 2 years in order to secure these and to do whatever. I'm just making that number up. I don't know the complexity of the change. But if the concern is we're going to drag it down, I doubt it. That would not be my recommendation to the director. Plus everyone would hate us. But yeah, it's a matter, I just reread the email, and it's just a matter of absorbing change, living through change, and then having enough staff to accommodate it. And the email from my colleague said at least 2 higher level staff, or 2.5 OA4s, for example, would be required. In the grand scheme of things, that's peanuts in an $18 billion state budget, but it would be something we would have to take back and consider putting in our budget, or add it to session law at the end of this bill. Well, no, we don't want to do that because we don't want a finance referral. We would need to address that somehow.
Yeah, so what I think our PIG can do is still note, you know, different, like maybe we recommend, and I think, yeah, well, in our PIG we'll have to figure this out. Maybe our ultimate recommendation will be the judicial process, but then also like letting the legislature know that it would be more user-friendly to do it through DOH, noting DOH's concerns, but still saying like legislature has that option, or vice versa. You know, maybe our PIG will recommend doing the administrative option, but then saying if the legislature is concerned about, you know, DOH's constraints, it can also adopt this judicial process. But I think no matter what, our PIG is in favor of having the denial of parentage available somehow.
Yeah, either sounds reasonable to me, and I, like I said, it's not going to be a showstopper from the bill's policy trajectory.
Okay. Yeah, so I don't want to get, you know, I don't want to risk violating the sunshine law without a quorum here. So I think I don't think our PIG probably needs a vote on anything at the next meeting. It sounds like we can probably finish our final report without needing to like get a definitive vote on something. But
Lauren, sorry to interrupt. Can I finish my questions about the professed parent section before you conclude? Right?
Yeah, sure.
I know everybody's leaving and I need to leave as well, but so we didn't get into like a too deep of a discussion last time, and I know there've been several months where this has been on the agenda, but I'm still having trouble with this conceptually, and I think it's around this unknown parent father question, and so, you know, reading the language you guys have in the memo, it says that the process wouldn't be used if there was a possible genetic father, right? And then I think the example that you guys have in there says, you know, if the birth mom doesn't know the name of the father, and so I'm just a little like I'm feeling the sort of concern about ensuring rights of potential fathers. I know you guys discussed that, but what's the sort of factual predicate for this? Like, what's the scenario that this addresses, and what would the person have to allege? It's like, I feel like if you just say I don't know the name of the father, that's probably not enough because that's too easy to say, and that's
right. Yeah, no, it wouldn't just be
like,
the name of the,
or even like I don't know who the father is. Like you could say that. You could have, you know, 2 boyfriends and not know which one's the father and say I don't know. Like, so you know what I'm getting at? You could have gone to a party and had sex with multiple people and know every one of them, but not know who the father. Like I'm struggling with this sort of guardrails to prevent people from just using this process to cut the genetic father out. And it's not super theoretical. Like I do have a friend that I learned a couple months ago that has a 23-year-old son from an old girlfriend who, you know, kind of, you know, moved away didn't tell him that she was pregnant and whatever. So I mean, I know there's circumstances where sometimes, you know, this sort of thing happens where the genetic father is kind of cut out of the life of the child, and so I'm wondering, I'm just slightly concerned that this makes it like a streamlined sort of process that's not, you know, doesn't have notice provisions or whatever that might facilitate that, and I think it centers around this idea of just how do you establish that something is unknown. And if you guys have thought about this in more detail, maybe you can make me feel better about it. That would be great.
Yeah, so yeah, it wouldn't just be like, I don't know the name of the father, or I don't know exactly who it is. I think it would be limited to situations where you don't know who it could possibly be, which is
So then what circumstances would that be, if you don't mind?
It could be, yeah, it could be assault. It could be yeah, or it could be like not knowing, even not knowing the name of the person. I think that qualifies too, because how could you give notice to someone you don't know what their name is?
So if you don't know their name, but you could find out their name, like, you know what I'm saying? Like, is there some responsibility to do some kind of due diligence to, what if somebody tells you their name later? You know, I don't know.
In the adoption context, this requires notice by publication, just to put it out there, because the scenarios you're talking about occur all the time. I get those all the time.
Yeah.
I was at a party, I had too much to drink, I got into a sexual situation with somebody, turned out pregnant a while later. I don't know whose house it was. I don't know the people at the party. I don't know who the guy was. You know, that happens a lot. But with adoption, we require notice by publication. I'm not recommending that necessarily. I'm just saying that's how we address it elsewhere.
Yeah,
And that sort of begs the question, are we not just talking about adoption here and a process that's already been designed to address that concern about the rights of the other person?
Adoption, would it actually resolve the issue I raised earlier, now that you say that?
May I say something? As far as Carol raising the publication requirement in adoptions, the whole idea is that you are creating a legal relationship with a new set of parents, and therefore you don't know who's out there in terms of being the biological parent. Therefore, if they're unknown, you give a publication to meet the due process requirements as to that person. And she is simply saying that that concept may be carried over in this situation where you have someone indicating that there is an unknown person because they either had sex with many persons or they were at a party and they did not get that person's name, but did have sexual intercourse. It could be any number of situations, but there is someone out there who is a biological parent. And the question is, what type of due process do you give them?
At least for now, that's how we answer that question in the adoption context. Yeah.
Yeah, I mean, I think we've
I'm not necessarily recommending it. I haven't thought about it.
Yeah. I mean, the way that we've, I guess, addressed it is, or try to deal with it, is just to have that be an attestation, you know, that there is no one else that person could give notice to, or that you know of, right? And that's why there's judicial oversight of it.
I'm so sorry to chime in so much. I will say I just received from the court, from judicial oversight in a similar case, in an adoption context where we don't know who the natural father was, a list of, have you checked with the state hospital? Have you checked with the jail? Have you checked with this? Have you checked with, so the judicial oversight in the adoption context can be quite extensive. I don't think the state hospital will even give me that information, quite frankly, but I'm going to ask the question.
Yeah.
So I'm not, again, not suggesting it here, but when there is true judicial oversight in the adoption context, at least recently, that's been a 2 to 3 page list of additional things they want me to do to make sure there's no way to identify the birth father.
Yeah, understood.
Yeah, so I guess if there was some indication that would be required in this, that would make me feel a little bit better. But I don't know. I didn't read that from the memo or the draft. I mean, it seemed like it was designed to be uncontested proceeding, like where there's already an assumption going in. You make this certain types of allegations and then you just sail through or something. And maybe I'm just not familiar enough with it.
Yeah, and I think that the thing that we're like the starting point for this is trying to make things equal between you know, people who obviously could not be the natural, like, you know, same-sex couples, and now like men who can just say I'm the biological parent, even though there might be someone out there who might be entitled to notice, but who's not going to get due process at all just because some other guy said I'm the biological father, and like everyone takes that as face value, and no one, there's no process to look into that. Meanwhile, if you happen to be a woman, you're not, you know, you have to jump through all these hoops just to be able to do the same thing. But anyway, that was kind of our starting point, but I understand the concern about, you know, protecting, you know, making sure that whoever is known to, if there is a possibly known genetic parent out there, they get some notice too.
Yeah.
It might be helpful to discuss this again when Judge Hall is here, because she obviously is very
Yeah.
familiar with these mechanisms. So I'm sure she thought of this. It would be helpful to know what her thought process was.
Yeah, so, and we can talk about this in our PIG as well. But yeah, I don't want to, I think we're getting close to deliberating right now, so I don't want to do that. But yeah, well, I think, I still don't think we'll probably need a vote. I think we can discuss this within our PIG and come up with something in our final report that addresses all the concerns. But yeah, that's just my anticipation right now, is that we're probably not going to come back with a vote, with something on the agenda for a vote. So it sounds like next time we'll probably just do a vote on the birth heritage pigs, Article 9 adoption issue. If that makes sense.
Can I
okay.
send a proxy? No, just I'll figure it out.
I don't.
Oh, and then next time we'll.
So why don't you want to vote on this? We do need some sort of vote on adopting the recommendations of the legal parentage pig, right?
So we are going to vote on the final report of the pig and whether to adopt the ultimate report and the recommendations. But I think our pig can address all the concerns without having to come back and have the whole task force tell us.
So like right now, if it was like written as is, I would vote no, but I really only have objections to that professed parent one, not so much on the denial one. So you know what I'm saying? Like, are we not voting on the policy provisions?
We will once we have a final report, then there will be. Yeah.
And I don't want to be like, I know you guys have put a lot of hard work into this. I don't want to be sort of, you know, naysaying. I just yeah, it's this piece was stuff that I thought a lot about mainly because it was different from the UPA, and it just made me think about it a lot more. But yeah, I appreciate you guys looking at that. I don't really fundamentally have a problem with creating another proceeding. It seems like it's in my mind, it seems super narrow in terms of who it addresses, and then it potentially creates problems, which I think you guys are going to talk about. But thanks for thinking about it.
Carol, did you have?
Yeah, so sorry, just one last procedural. So when we're voting on the reports of the pigs, we're voting on take it or leave it, or we're voting on individual policy questions inside the reports?
Well, I think people could, like, you could vote on take it or leave it. People could make motions and say, like, I vote to adopt the report except for something where I support the minority view instead, something like that. But I just don't want to have like the final reports be produced and then, you know, the task force being like, we don't want any of this.
No, of course. Yeah. Of course. Okay, thank you.
Okay, thanks. All right, so I'll adjourn the meeting at 3:18. So yeah, next time we'll do the drafting pig formation. And I'm not saying that our pig is not going to come back with a vote on something, but if there are things that the pigs need to have votes on, let us know so we can put them on the agenda for next time. And yeah, keep in touch. The next meeting will be August, or
Yeah,
sorry,
July
July
5.
July 5th. All right. Thank you, everybody.
Thank you, everyone. Bye-bye. Have a good weekend.
Deadline is the 28th.